Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today because you have a case in this court. The case that you have is a misdemeanor case. It's a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your most serious type offenses. And what I mean by serious, basically, we're talking about the facts of the case as well as the punishment that you can get if you are convicted for committing a felony. The misdemeanor cases are normally referred to as a petty offense. It does not mean that they're not serious. It just means that they're not serious. We're talking about the facts and the punishment. Felony cases are divided into 5 categories. It's divided from, you have a capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you're convicted of a state jail felony, the range of punishment is minimum 2 years to minimum of 6 months to a maximum of 2 years in the state jail, a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is a minimum of 2 years to a maximum of 10 years in the state penitentiary, a fine all the way up to $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life in the state penitentiary without parole or death by lethal injection. You don't have to worry about that because you have a misdemeanor case. Now, your misdemeanor cases are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If you're convicted of a Class C misdemeanor, the range of punishment is by a fine only. So you can't get any jail time. You only could get a fine. And normally those cases are handled in the city court or the JP court. For example, like a speeding ticket is a Class C misdemeanor. Not wearing your seatbelt is a Class C misdemeanor. Or if your sticker or your license plate is expired, that's a Class C misdemeanor. Now, we get those cases when those cases are appealed from the city court or the JP court. Then they come up here, but the range of punishment is still the same. It doesn't change. Now, if you are convicted of a Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, a fine from $0 to $2,000, or you could be given both such confinement and the fine. If you are convicted of a Class A misdemeanor, the range of punishment minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such confinement and fine. Now, as a defendant in a criminal case, you have rights. And one of the rights that you have is a right to have an attorney. And the paperwork that is on the clipboard that you have talks about your right to have an attorney. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. And now on that document, I'll go over this document with you. It states, as a defendant in a criminal case, you have 3 options. When we talk about 3 options, you have 3 options regarding your right to have an attorney. Number 1, that's the first option. You may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, the third option is you may represent yourself. Now, if you want to waive your right or give up your right to have an attorney, you can represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so, to give you time to hire an attorney. If you want an attorney and you do not have the money to hire an attorney, then you would have to fill out a financial questionnaire. Now, that financial questionnaire is on that tablet as well. It's titled Jefferson County Affidavit of Injuries. So you'd have to fill that document out, and then the proper person will determine or decide whether or not to appoint an attorney to represent you. And if you want to waive or give up your right to have an attorney, that is, if you want to represent yourself, you cannot speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. What that basically means, the prosecutor is an assistant criminal district attorney. So they work for the DA's office. So if you want to talk to them about your case, you can't talk to them about your case unless you are representing yourself. So, and in order to represent yourself, you have to sign a waiver, which basically says that you have a right to have an attorney, you know the dangers and consequences of representing yourself. However, you still want to represent yourself. You want to waive or give up your right to have an attorney to represent you, and you want to represent yourself. Now, that's the second form that's on that tablet. I'm going to go over that with you after I finish going over this first form. Now, and so once you sign the waiver, then you may speak to the prosecutor about your case. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, that basically means if you decide to represent yourself, you may change your mind at any time. So if you decide to represent yourself, you talk to the prosecutor, and then after that, you say, well, I changed my mind, I want a lawyer. That's fine, you can do that. That's what the last sentence on this form says. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. So you may request an attorney from the court. Now, at the bottom of the document, in bold letters, it says defendant's choice. Mark initials next to only one choice. Now, if your choice is to hire an attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney, that is to give up your right to an attorney and to represent yourself, then you will place your initials on the fourth line, on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant. And you will date it today's date, June 6th of 2023. Now, for those of you who will be waiving or giving up your right to have an attorney, and you are desiring to represent yourself, you will have to read and sign the next page that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And that document states that I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 6th day of June 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that is your choice, then you will sign your name on the line that is titled defendant, and you would date it today's date, June 6th of 2023. Now, as a defendant in a criminal case, you have other rights. One other right that you have is a right to have a trial by jury. In that area that you see the young man sitting in, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case, and they will decide whether or not you're guilty or not guilty after listening to all the evidence. You also have a right to waive or give up your right to have a trial by jury. And if you do so, you will not be having a trial by jury. However, your case will come before the court or before the judge in one of 3 ways. One way it can come before the judge by way of a trial without a jury. It's a trial by judge only. We call that a bench trial. Now, you can also waive your right to have a bench trial. And if you waive your right to have a bench trial, then your case will come before the judge by way of a plea bargain. It can come by way of an unagreed plea bargain or an agreed plea bargain. Now, if it comes by way of an agreed plea bargain, what that basically means is a plea bargain is you and the district attorney or you and the prosecutor have worked out a settlement on your case. Y'all settled the case. And you want the judge to decide whether or not the judge is going to accept that settlement or reject that settlement. Now, the other way your case can come before the judge is by way of an unagreed plea bargain agreement. That is, you and the state have not been able to reach a settlement on the case. And you want the judge to decide what your punishment will be in the case. Now, as a defendant in a criminal case, if we have an agreed plea bargain agreement, the judge don't have to follow the plea bargain agreement. If the judge does not follow the plea bargain agreement, you will have a right to take back your plea. So for example, let's say you and the state has worked out an agreement, and the agreement is for you to pay a fine of, I'll just say $50. And the judge in the court says, well, I'm not going to follow that plea bargain agreement. Then you say, well, judge, I take back my plea. You can do that. You have a right to do that. You have a right to withdraw your plea. Now, if the judge does follow your plea bargain agreement, let's say it's $50, the judge follows the plea bargain agreement, and then you say within 30 days of that plea, you say, well, you know, I think I've been wrongfully convicted, or they committed an error by convicting me. I want to appeal my case. That is, you want to have a higher court than this court to review the case to see if you've been wrongfully convicted or whether or not an error has been committed by this court. Then if you want to appeal your case and the judge has followed the plea bargain agreement, you have to get permission from the judge to appeal your case. The judge can give you permission or not give you permission. Now, if the judge gives you permission to appeal your case, then your case will go from this court upstairs to the appeal court, to the Ninth Court of Appeals, which is on the 3rd floor. They will review your case, and they can decide whether to grant your appeal or deny your appeal. If they grant your appeal, then they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, that is, if the Ninth Court of Appeals deny your appeal, you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. They're located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means you'll be filing this petition without the assistance of a lawyer. You'll be representing yourself. We call that pro se. And so the Texas Court of Criminal Appeals, they could either grant or deny your petition. If they grant your petition, then they can find you not guilty, or they can send the case back down to this court or the appeals court and order the appeals court, order this court to give you a whole new trial, or they can order the appeals court to give you another hearing. The next thing is, if they grant your, if they deny your petition for discretionary review, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. That chair right there with that microphone in front of it, we call that the witness stand. And what witnesses do, they will come to court, they can testify. They can testify either for you or against you. Now, as a defendant in a criminal case, if you're representing yourself, you have a right to ask them questions. Or if you have a lawyer, your lawyer have a right to ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to give up. You also have a right to waive your right to have witnesses. What that means is you have a right not to call any witnesses in your case. You're waiving or giving up the right to call witnesses. And if you do so, that does not mean that the state will not be calling witnesses. It just means that you will not be calling witnesses. However, the state will be calling witnesses because they have filed the case against you. Now, the next thing is you have a right not to testify. We call that a Fifth Amendment right against self-incrimination. I know sometimes you might watch television or you might have heard the phrase, somebody say, I take the fifth. That means I ain't saying that. Okay. And so you have a right to take the fifth. You have a right to exercise your Fifth Amendment right against self-incrimination and not testify in your case. The state of Texas, the prosecutor, the government cannot force you to testify in your case. Now, you can waive or give up your right, your Fifth Amendment right against self-incrimination. And by doing so, if you waive or give up your Fifth Amendment right against self-incrimination, you will be testifying in your case. Now, you also have a right to have discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right to see videos, audio record, you have access to audio recording, documents, instruments. You have a right to see witness statements. Whatever evidence the state has against you, you have a right to have access to that evidence. We call that discovery. Now, you also have a right to waive or give up your right to have discovery. What that means is you have a right not to have to say, well, I don't want to have access to the evidence that the state has against me. Now, as a defendant in a criminal case, as I mentioned earlier, you have those rights. Those are some of the rights that you have as a defendant in a criminal case. Now, everyone that's here for their case, you here because you've been arrested. In essence, you was placed in the Jefferson County Jail, or you've been in some county jail, and you are out on bond. Now, you're either out on a cash bond, which means you paid the full amount of the cash to get out of jail, or you are out on a surety bond, which means you paid a bondsman a percentage of the money to get out of jail, or you are out of jail on a PR bond, which means you did not have to pay any money to get out of jail. However, you had to make a promise to appear here in court. Now, every day that you spent in jail, that time can be used as credit towards your punishment. So, for example, let's say you in the state, let's say you spent 5 days in jail, and let's say the state of Texas or district attorney's office is offering you, y'all came to a punishment agreement for you to do 5 days in jail. Well, that basically means that you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already spent in jail. Now, if they offer 7 days in jail and you serve 5 days in jail, that means you have to do 2 days in jail because you'll be given credit for the 5 days that you've already spent in jail. Now, every day that you spent in jail also can go toward your fine and court costs. You can get credited $100 toward your fine and your court costs. So if you spend 5 days in jail, that's $500 that can be credited toward your fine and court costs. So if the state is offering you fine and court costs of $500, that simply means you won't have to pay any money. Why? Because the 5 days that you spent in jail, you got $500 credit. You've already, the time that you spent in jail has already paid off the fine and court costs. Therefore, the fine and court costs will be what we call taxed and retired. You won't have to pay it. Now, if they're offering fine and court costs of $700 and you spend 5 days in jail, then that means you would have to pay $200 on the day of the plea. Now, if you can't pay the $200, then we can convert the $200 to community service. And what that means is you would have to work off the $200 at a nonprofit organization in the community. You will get credited $12.50 for every hour of community service that you do. So 8 hours of community service is $100. That will go toward your fine and court costs. So if, for example, they are offering $700 fine and court costs. You did 5 days in jail. That's $500. You got $200 left. It's been converted to fine. It's been converted to community service. That means you would have to do 2 8-hour days to work off the fine and court costs. Okay. Now, the other thing is, if you have not been in trouble before, Jefferson County has a program that is called pretrial diversion. And in short, they'll dismiss the case and you can get it wiped off your record. Okay. And the way it works, you would have to, it has to be your first offense or your first time getting in trouble. And you have to have a lawyer to assist you to get into the program, just to write the letter to get into the program. And the third thing is it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. So for all other offenses, you can qualify. All right. Now, if you're interested in that program, just let us know, and we can assist you at getting the help that you need to get into that program. The other thing is this court has a program that is called the pretrial, that is called the CSI program. CSI stands for Community Safety Initiative. That program is designed to address the issue of what we call recidivism. Recidivism is just a word that basically means people commit crimes over and over. And so how do we stop people from committing crimes? Well, we believe that through our community safety initiative, we can do that. And the reason why we believe we can do it because there's a cycle that individuals gets in. Normally, the cycle usually starts when you can't get an education, and you can't get a job. You can't get a job, you normally get depressed, turn to drugs and alcohol. Once you turn to drugs and alcohol, you eventually commit a crime. And once you commit a crime, you eventually get caught and do time. And once you do time, you're going to get out and then you're back in that same cycle. And so how do we break the cycle? We break it through the Community Safety Initiative. And with that program, we have partnerships with agencies in our community. One of the partnerships that we have a partnership with Spindletop Center. Our Spindletop Center is a local mental health center here in the Jefferson County area, or we could say Southeast Texas. And so with that program, they'll be able to do a private interview. They can do an assessment, develop a treatment plan that will be able to address your needs, either outpatient, inpatient services. The other thing is they have a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. And also our local Drug and Alcohol Council has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referral Services. And basically what those programs is drug and alcohol treatment programs for individuals that have issues with drugs and alcohol. And the way the program works is they will do screening, they do an assessment, and treatment plans can also be developed either outpatient or inpatient. The other part of the program that we have in our Community Safety Initiative is a partnership that we have with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program, and in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas that you choose, they will assist you at getting a job in the area that you are trained in. Now, if you have not graduated from high school, they have a GED program where you can get your graduate equivalency diploma. So in all of those programs that I just mentioned to you, they are free, does not cost you anything but just your time to participate in the program. Now, all of these programs, this program, the CSI program, I started in March of 2017. Actually, it's been 6 years since I got elected to this position. Within the first 100 days of taking this position, I started that program. And there have been hundreds of people that have benefited from this program. Now, this program, I tell people this, when you come to county court at law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the life of the individuals that comes before this court. And we're trying to make a difference in the community in which we live. We do not just give time, we take our time. We do not just arrest the problem, we address the problem. And we believe that by addressing the problem, we can produce productive people. And if we produce productive people have too much to lose and they will not commit crimes. So that's in a nutshell what our program is about. if you're interested in the program, just let us know. We have some brochures. And also, the gentleman that I had referenced earlier is Deputy Hinton. He's with Spindletop. He's a mental health officer. He's going to come to you today and tell you a little bit about the program that they have to offer at Spindletop for you. At this time, Deputy Hinton. You're welcome.
Good morning. My name is Steve Hinton. The reason I am here today is because the judge cares about every single person who comes before the bench. The judge found, and what statistics prove is those who have legal issues commonly have mental health needs, such as use disorders, or sometimes just a lack of community resources. The judge believes he can help you with these underlying issues. He can get you out of the cycle of arrest. That's our goal. That's our cycle. Maybe this is your first time to be here. Maybe it's your 10th time to be here. There's still hope. This program actually has the ability to change your life, but we're going to need something. We're going to need you to share that need. When you first came in here, I handed out this form here. It's a resource demographic. It's not a court form. It's for us only to share that need with us so that we can see how best to serve you and provide resources to you that best fit your particular situation. It is HIPAA regulated, it is private, it will not be shared outside of your permission, but we will ask you to legibly write phone numbers, however you choose to be contacted or connected with, so that we can communicate with you and best get you pointed in the right direction. Also, I have a flyer here. It tells you a little bit about the advantages of the program on the back, and on the front, it also has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. We did this to everyone before we were here today. Shortly, the court is about to go into recess. When they do, I will be out in the gallery with y'all. I'll pick up this form here that you filled out. If you have any questions, I'll be glad to answer any questions, and I'll also get this in your hands. Thank you. Thank you, Your Honor.
Thank you, Deputy Hinton. Now, ladies and gentlemen, before we go into recess, the paperwork that you have in your hand, we're going to pick that paperwork up from you. Now, if you need some assistance at filling out the paperwork, we have our court personnel who's here who will be happy to help anybody that needs assistance. Now, once we pick up that paperwork, then we're going to call you up one at a time before the bench. And then once your case is finalized, either you'll be put into one of three categories, whether or not one category is to hire an attorney, second category is to see if you qualify for a court-appointed attorney, or the third category is to waive your right to an attorney to represent yourself. And if that's for those who waive their right, then they'll talk to a prosecutor about their case. Now, this process is going to take a little time. If you need to use the restroom, there are two restrooms right outside the courtroom, to the right of the courtroom. And the men's restroom is in front of County Court at Law number 3. And the women's restroom is on the opposite side of the hall in front of the 72nd District Court. Okay, so at this time, the court is going to go into recess. And if you need assistance, just please raise your hand and we'll have someone, she's standing right by the wall. She'll be able to help you with filling out the work. This time the court will be in recess.